So good afternoon, everyone. We are happy to start our spring webinar series within a BHR Mentorship Program for Early Career Researchers in Ukraine. And we developed 5 webinars on different angles of human rights and business role in that. And our first webinar is on investment treaties and human rights. And we are extremely happy to have 2 incredible speakers today, who are Anil Yilmaz, a senior lecturer at Essex Law School and Human Rights Center, and Tara Van Ho, who is also a senior lecturer on Essex Law School and Human Rights Center. We will discuss and proceed with the program as following. So each of our speakers will have 20 minutes presentations to cover different aspects of our topic, and then we will proceed to open Q&A section, and everyone is very welcome to raise questions through the chat or by raising the hands. We will be very great to discuss and develop the theme through the talks with our speakers. And Anil will start with an introduction on international investment law and how international investment protection might interfere with protection of human rights, environment and climate change. And Tara Van Ho will proceed with a discussion of investment law in armed conflict and post-conflict transitions. And we are very happy to start. Anil, please, the floor is yours.
Thank you, Tamara, and thank you, Olina, for organizing this and inviting us to speak. Can you hear me all right? Okay, great. I'm going to do an introductory kind of presentation on international investment law and its interaction with human rights protections, with environmental protection and climate change, and there will be some discussion with an initial discussion on kind of introductory points on what international investment law is. Can I actually ask for our participants how many people here have studied or worked on international investment law before? If you have done, can you do like a thumbs up on the, because that will help me kind of understand how much detail I should go into in the introduction. Okay, so we have someone who's done, Irina, thank you so much. But majority of people here have not really studied or worked on international investment law. So that helps me because that's how I kind of structured my presentation. I'm going to share my screen. Right. Can you see my slides? Right, okay, so I'm gonna just right. So I wanted to start with kind of explaining what international investment law is, what it does. International investment law is a subfield of international law, and it sets international standards on how foreign investors should be treated by host states in which they invest. So if we have, say, a Ukrainian investor investing in the United States, it's about how the Ukrainian investor or its business and its investment should be treated when it within the United States of America. And this is actually not a hypothetical example anymore, obviously, because the US has become a rogue state. So, you know, they might take property or interfere with foreigners' businesses. So that's what international investment law does. And the idea behind having this kind of protection that is embedded in international law, rather than having protections in domestic law, which we have in most jurisdictions anyway, there are certain level of protections that protect investors or property. But this goes beyond that, basically. This is international guaranteed protections. And if we look at why we have this system of protection, I mean, I could go into very much detail on the history of it, but if we look at the basics of it, the rationale, the justifications often offered are that if we offer international protections, we're going to attract more investment. And that's good for economic development and growth. That's how the argument goes. More foreign investment means better economic outcomes, although that is a contested suggestion in economics literature. That kind of is what primarily underpins the logic of international investment law. There's also the argument that it creates good governance effects, that if states have to comply with international standards on that basically require them to comply with principles on expropriation or treatment of investors, that will have good governance effects, that will enhance rule of law in the domestic jurisdiction. It also, and this links back to the first justification, mitigates political risk for investors and enhances access to justice for them, because they can access international arbitration, which I will talk about, if states interfere with their rights protected under investment law. If we look at the sources of international investment law, we have primarily international investment treaties. These might be bilateral treaties, or they might be plurilateral treaties, free trade agreements with investment chapters. They're signed by and between states to offer protections to investors, basically. So their beneficiaries are not the states themselves, they're primary beneficiaries, but they're the investors that are protected by these treaties. So business people, firms, corporations, etc. But they can only receive the protection when they invest in the territory of the other state. And then there are also investment contracts. So these are contracts that are signed between the investor and the host state, the state that hosts the investment. And even though they can be in most, for most purposes, they are contracts. They can have provisions that refer to international treatment standards and international dispute settlement. So they're part of the sources of law when we look at international investment law. Also, many states, especially developing states, have national laws they have legislation that promotes foreign direct investment, and they often refer to these international standards that I will talk about shortly as well. And then investors can also invoke general principles of international law. They do sometimes do that to supplement treaty interpretation or supplement treaty provisions. And then we have what is called the ICSID Convention, the Convention on the Settlement of International Investment Disputes. And this convention was signed in 1965, and it basically focuses on dispute settlement. It offers arbitration proceedings options for investors, and the convention itself allows arbitral awards made under the convention's provisions, auspices of the convention, to be enforceable in all signatory states. Which makes it a really powerful tool, because if you have an arbitral, it's harder to enforce court judgments overseas. It's much easier to enforce ICSID Convention awards. Well, it's not that easy. States will challenge it, but comparatively speaking, it's easier because you will have, if a state has signed and ratified the ICSID Convention, they have to enforce an award validly made under that convention. So I'm going to focus on investment treaty standards because they're more standard and they're more prominent and relevant to the discussion. So typically an investment treaty will contain protections against expropriation, meaning that expropriation per se is not prohibited, but it can only be done for a public purpose, following due process, and with adequate compensation paid for the expropriation. So expropriation can be done, but it must be done following these principles. Then often the disputes boil down to either the amount of compensation paid, or whether due process was followed, or whether even the expropriation was made for a public purpose. There are two types of expropriation that are often invoked under investment law. One is direct, so direct taking of property, physical property or physical assets, or even, nowadays, non-physical assets, but direct takings. And then there's what is called indirect expropriation, where you're not taking the assets of an investor, but you're passing a series of regulations as the state that basically deprives that investment of the value that it has. It could be that you cancel the license of a mining concessionaire, and so even though they have all the equipment, they can no longer exploit that mine. So you haven't taken anything physically or any assets, but you have basically taken away their right to do something. Or you might introduce really costly regulations or taxes that might be considered indirect expropriation because of the substantial deprivation it gives rise to in the value of the investment. Then we have the non-discrimination standard, which is very kind of obviously it's an international, not just an investment treaty standard, but all international economic law embraces this standard. And that includes most favored nation treatment standards. So it basically entitles investors to have the most favorable standards that state affords to investors from other nations, as well as the national treatment standards. So it prohibits discrimination between nationals and foreigners in the policies. There are some exceptions to this, obviously, but they're quite limited. A very problematic standard that we see in investment treaties, which has a lot of bearing on questions of human rights and environmental protection, is what is called the fair and equitable treatment standard. It's a standard that requires the state to refrain from, arbitrary treatment of the investor, denials of justice. But it also is understood to protect the legitimate expectations of the investor, which can be quite a far-fetching standard. It has been interpreted in case law in a really expansive way. Investors' legitimate expectations can be interpreted in ways that really limit ability of states to take regulatory action in different areas. Then another mainstream standard that we see in investment treaties is the full protection and security standard, and that requires host states to ensure that investors' assets and staff are protected from uprisings, etc. But these are not simply protecting investors from everyday interference, but if there is a civil unrest or if there's conditions of war, then there is a requirement that state provides protection. If it doesn't, then it might be liable to pay compensation. What is quite significant about investment treaties is I think their standards as well as the dispute settlement method, because the dispute settlement method is what makes it so powerful and so kind of gives it the power to interfere with other state obligations. So dispute settlement will be typically via international arbitration, and I've looked at Ukraine. So if you go to UNCTAD, one of UN agencies that focus on trade and development, has a dispute settlement navigator. So if you look at there, they have a record of all publicly known investment treaty disputes or investment disputes in general. And if you search Ukraine, the most recent dispute that was filed against Ukraine was by this bank that was nationalized basically after the start of the war. And so they filed a claim against Ukraine, arguing that Ukraine, and this claim was filed under the Luxembourg-Ukraine Investment Treaty, because this bank's shareholder is incorporated there, but this is of course not the actual shareholder. The beneficial owners are Russian citizens, and so you had the bank filing this claim, they're arguing that Ukraine owes them at least 1 billion in compensation for having breached the standards that we see in the Luxembourg-Ukraine Treaty. And I will talk about those standards in a short while. Now then, interestingly, recently I had come across another case so that was brought by Mikhail Friedman, who's the beneficial owner of the ABH, the bank that was confiscated, the holdings. He filed an investment arbitration claim against Luxembourg under the treaty between Russia and Luxembourg. And he's demanding at least 16 billion in compensation for the EU sanctions that froze his assets, his and his business associates' assets. So for me, it's quite interesting to see that on one hand, his company is relying on the treaty that is between Luxembourg and Ukraine to pursue Ukraine in investment arbitration. But on the other hand, he himself is suing Luxembourg under another treaty for the sanctions. So this is how sometimes ridiculous the system gets, because investors can set up companies to benefit from different investment treaties. Normally, this is supposed to be benefits of the system are supposed to be granted based on the investor's nationality, but obviously many investors being corporations, they can alter that nationality, they can incorporate, they can shop for different treaty protections. So that's interesting, and I think there's a lot to be unpacked about the first case when it comes to questions of investment treaties and armed conflict. Because the assets of the bank were taken in the context of a war of aggression, right? So there's a lot of interesting things to consider there. We don't know, these cases are pending. We don't know what will happen. They could take several years to be resolved. So what I want to focus on going forward in my allocated time is how state obligations under international investment law, so to provide these standards that we just talked about, might hinder states from taking measures in the public interest or national interest, or it might make it more costly for states to do so because of the levels of compensation typically awarded in investment arbitration are much higher than other dispute resolution systems because of the formulas and assessment methods that they use. So that's also a very problematic area. And how does this relationship come to be between international investment law, human rights, and the environment? Now, on one hand, we have state obligations under international investment law that are highly enforceable through a very robust dispute settlement system. On the other hand, obviously, states have obligations under international human rights law. They have obligations under international environmental treaties, also regional treaties, and many of these standards are also embedded in national constitutions of many states. And I would like to also emphasize that if we think about, for example, economic, social, and cultural rights, they require progressive realization using maximum available resources. Now, when we look at quite a few, which I will talk about, investments treaty disputes, there are many where private investors who, for instance, run services like water provision or sanitation or kind of engage in extractive activities might have hindered the realization of these rights. And as a response, a state might take actions to ensure that either the investor complies with international standards or might cancel the license of the investor or nationalize the business. And this might give rise to an investment dispute. Now, as I said, there is a very strong enforcement mechanism there when there's an investment dispute. But if we look at how international human rights obligations of states and environmental standards are enforced, With human rights law, obviously we can, one can resort to domestic courts, regional human rights courts if they're available, but they're not available everywhere in the world, right? One might resort to UN treaty bodies, but these are quite limited options. They're not as powerful in terms of a remedy mechanism as investment arbitration is. And they require, even the regional or international systems will require exhaustion of local remedies. So that kind of, if I'm a state and if I have to comply with different sets of international obligations, it will be less appealing to comply with my human rights obligations if that means that I have to breach my investment law obligations, because the consequences of not complying with my investment treaty obligations can be more dire. So I can see that I'm going to be running out of time soon. So I'm going to just continue with this and then pass it over to Tara. So how may investment law protections impact human rights and the environment? Now, it may be that the investment itself, as I said, like in water provision, is in a business activity that directly involves a human rights or environmental interest. And in that case, there's a question of how far state regulation of that interest may be considered a breach of an investment treaty standard. We've seen this during the financial crisis in Argentina in early 2000s, where the severity of the financial crisis meant that the state had to intervene and take really drastic measures to regulate utility sectors like water, electricity transmission. They were all owned by foreign investors. And then it faced a barrage of claims in investment arbitration because of the alleged breach of investment treaty standards. And then it may be that, like an extractive investment, mining or petroleum extraction, you might have a situation where the way in which investment is carried out may cause pollution, it may cause displacement of people, so there is an impact, there may be an impact that way. And if, again, the state interferes in a way that reduces investor profits, that may then cause an investment dispute to arise. Sometimes investment law demands may restrict states' ability to fulfill human rights or cause what is called regulatory chill. So states may refrain from regulating to avoid investment treaty claims. And this is what we're seeing currently in the fossil fuel sector, where governments are increasingly having obligations to phase out fossil fuels, but on the other hand, that will be a very costly thing for states to start early retiring coal power plants, etc. So that can cause this kind of friction. And sometimes arbitration awards may restrict state ability to allocate resources to realizing human rights or environmental protection because of how high the amounts might be. I have included here the treaty that was invoked by the Russian bank from the Belgium-Luxembourg Economic Union Investment Treaty with Ukraine. So they invoked the provision on fair and equitable treatment standard. They said that the taking of the bank's assets was a breach of Article 3, Paragraph 1, which requires the investor to be treated fairly and equitably. But that's all. I mean, we don't know. This treaty, all the treaty says about this is this, right? So all the rest is filled kind of by investment arbitration tribunals as to what fairness and what equitable treatment means. And then they invoked also Article 4, which is about expropriation, that there must be a payment of compensation, it must be for a public purpose, and that there must be a due process of law that is followed, non-discriminatory, etc. So there, I'm guessing, arguing that this was a discriminatory measure that did not follow due process, and there was no payment of compensation. There was a symbolic amount, I think, that was paid. Now, there is, I had a look at the treaty, and it provides no exceptions for states to get out of this kind of commitment if there was the situation of armed conflict, or any other kind of emergency. So we will see what happens in this case. I'm going to actually stop there and turn it over to Tara. Thank you.
Thank you very much, Anil, for very insightful presentations on basics of investment law. And please, just one more time, reminding all our participants, if you have any questions, please put them in the chat, or yes, reserve it to the discussion section, which we will have after Tara's presentation. Tara, the floor is yours.
Thanks. And thank you to Tamara and Elena for having us here. I am a little bit in a position of where I want to apologize to all of you because I am American, and yeah, so that's just a unilateral apology, not for being American, but for what's going on in the US right now. Before I start, I just want to, because Anil gave you a great deal of information around the foundations of investment law, that I'm going to build on to talk about investment law, particularly related to the Russia-Ukraine conflict. And so before I do that, can I just ask for any pressing concerns or questions that you had around that? If there's anything you didn't really understand, or anything you want me to talk about a little bit more in depth. Okay, there are no hands.
If
Go
may,
ahead.
yeah, just I think in Ukraine there is a huge discussion of how the investment treaties will work after renovating or during the post-war conflict. So how the business actors, both private and state ones, will proceed with facing requirements for this investment, and whether there will be some specific requirements for post-war rebuilding of Ukraine. So yeah.
Perfect, because that is the third part of my presentation. We'll cover that. I did decide, because everything else that I'm about to do for you is really depressing. Well, that's not true. The first part is really hopeful for Ukraine, but then I get to the really depressing parts for Ukraine. So I used pretty cherry blossoms to make you see something pretty amongst a presentation that is otherwise a little bit dire. So today, focus is obviously going to be on Russia and Ukraine conflict, and Il's given you a good overview of investment law. I want to highlight something that she said, which is that while I'll focus on the Russia-Ukraine bilateral investment treaty for the most part, that's not the only way in which investment law claims can be brought by Russians against Ukraine. And so they can, by structuring corporations via third-party states, they can actually rely on other investment law claims. But I'm going to focus on the Russia-Ukraine conflict, largely because it's quite unique. I mean, largely because of who you are and what this purpose is, but also because it's a quite unique conflict. A lot of the lessons that we have around business and human rights and armed conflict come from non-international armed conflicts. So you have some from Sri Lanka, where the Tamil Tigers were fighting the government. You have some from Colombia, where you had FARC and the ELN against the government. There's some from places like Congo and that become relevant as well. But we don't have really cases of an international armed conflict, so between two states, that had an ongoing bilateral investment agreement between them. So that makes what's going on in Russia and Ukraine quite different than what we have experienced elsewhere. It also means that there's not a lot that we can know for certain right now. Ironically, most of the lessons for the current conflict come from Russia's invasion of invasion of Crimea in 2014, and the cases that Ukrainians have brought as a consequence of that. As I said, there is a bilateral investment treaty between Russia and Ukraine. It was in effect until 27th January 2025, when Ukraine unilaterally terminated the agreement. I will explain in a moment why those protections will continue to apply through 2035, though. The situation is also unique because Anil talked about the international Convention on the Settlement of Investment Disputes and the center that's associated with that treaty. Russia is not a party to ICSID. Ukraine is. That means that actually there are more ways to take claims against Ukraine and more protections for Russians operating in Ukraine than there are for Ukrainians to take against Russia or for Ukrainians operating within Russia. And then finally, the other thing that's a little bit unique is your bilateral investment treaty with Russia does not include the fair and equitable treatment clause. But there are ways, as I'm going to explain in just a moment, to read that in. So the Ukraine-Russia bilateral investment agreement only includes a prohibition on expropriation and the provision of most favored nation protections. That most favored nations clause has been interpreted in other circumstances and other cases as extending protections that aren't explicit within the treaty to the investors, like to investment claims brought under that treaty. So you don't have fair and equitable treatment within this treaty, but you do have a most favored nations clause. Other treaties that Ukraine has signed do include the fair and equitable treatment standards. And so tribunals have, in those circumstances and other cases, read the fair and equitable treatment standard as applying even to cases and claims brought under this bilateral investment agreement. It's a really unusual approach when it comes to international law to interpret the treaty as requiring substantive protections based off of another treaty. But in investment law, it's not a unanimous reality, but it is a reality that some investment tribunals have found that they use this most favored nations clause as interpreting a treaty as including the fair and equitable treatment standard, even where that's not explicit in the treaty itself. The treaty was terminated unilaterally by Ukraine on the 27th of January, but it includes a sunset clause, which extends the life of the protection of the treaty for another 10 years. So all of the investments that were made in Ukraine by Russians prior to the 27th of January are protected within Ukraine, not just through the 27th of January of this year, but for the next 10 years as well. So Tamara, to answer your first question about how will the impact be on reconstruction, this treaty will continue to protect Russian assets in Ukraine until 2035. So that is probably your entire initial phase of post-conflict reconstruction. And then that's just that one treaty, right? Then you have the Luxembourg-Ukraine bilateral investment agreements, and you have other provisions and other treaties that will protect Russian assets as long as they are appropriately circumvented through these third-party states. Now, I could go into more on the nationality issues, but Anil has actually written an entire book on nationality and investment law that will explain how Russians can use those third-party or third state workarounds. So I'm not going to answer any questions on that. I'm going to leave it all to the world's preeminent expert on that issue. That's a no. All right, so there are three ways to talk about investment law, human rights, and the conflict. One is how to use investment law to recoup reparations for Ukrainian individuals and businesses that were harmed by Russia's conflict in the conflict. The second way is how Russians are using investment law to pursue Ukraine right now for its conflict-related activities, including expropriation of Russian oligarch property. And then the third is the use of investment law by Russian investors and others during the post-conflict reconstruction. Most of the literature around investment law and armed conflict focus, and this includes my own, focus on one or the other issue, right? So they either focus on how to use investment law to recoup reparations and protect investors, or they focus on the impact of investment law on reconstruction. But today I want to make sure that we cover all of it. So using investment law for Ukrainians and Ukraine. Ukrainians have already used investment law to recover losses caused by Russia's activities in Crimea. Most of these claims relate to physical expropriation of property and assets when the Russian government nationalized some of the Ukrainian infrastructure. Some of it we know relates to regulatory changes imposed on Ukrainians. Unfortunately, many of these decisions are heavily redacted. So it's not always easy to understand, first of all, the foundation of the claims, or to understand the reasoning of the arbitration panels. And it's the reasoning of the arbitration panels that can become quite important in investment law, particularly when we think about this regulatory chill and how will Ukraine respond to these investment agreements in the post-conflict reconstruction. And that's because oftentimes you have very inconsistent reasoning within investment law. So you will have the findings result in the same finding, which is oftentimes the state owes the investor money and reparations. But why the state owes investors that is really not a consistent reasoning. And so it will be very difficult for Ukraine fundamentally to respond to these cases in a way that means that Ukraine's insulated unless we can get to the reasoning to really understand what the tribunals are thinking and expecting of a state during an armed conflict. So it's not easy to understand the reasoning. What we have is the impact of the cases. Sorry, 1 second before we get to that. What we know is that substantively there are a couple of protections in addition to the prohibition on expropriation that can protect businesses in armed conflict. So the full protection and security clause or protection will often be used by investors to claim that any damage during an armed conflict to their property or during a riot to their property constitutes an investment law breach and should be subject to full reparation. Effectively, what the full protection and security clause does is require a host state to prioritize foreign investment protection during situations of upheaval. So any armed conflict or any rioting, any sort of anti-Russian retribution against assets within Ukraine, any of that could be protected by the full protection and security clause. And the same thing is true for Ukrainian property in Russia. You also have the fair and equitable treatment provision, which addresses regulatory takings associated with the annexation in Crimea. So these are the general provisions that have been used to make claims against Russia. Exactly how, like what the underpinning reasoning though is where it's been really difficult to get any clarity of. So far, Ukrainians have not lost a case arising from Crimea. So all of the cases by Ukrainians brought against Russia from the 2014 invasion have been successful for Ukrainians. This has included awards like 267 million for your private energy company, for the largest private energy company, 5 billion for the Ukrainian state-owned oil and gas company, and 1.1 billion for the state-owned bank. The awards have been upheld by Dutch and Swiss courts. And right now, because there are a lot of frozen Russian assets in Europe, and previously there were in the US, I'm not sure how much longer that will be true. Though once you have an award like this, you can attach it to those Russian state assets within Europe. And so this money could be recouped from the frozen assets within European states. So this does suggest that there's an avenue for using investment law to strengthen Ukraine's financial standing during the conflict and to strengthen the finances available for reparations. There is also an argument that we can talk about a little bit later that any damages done that could be used for investment law should be excluded from Ukrainian reparations programs during the post-conflict reconstruction. So that if you're a foreign investor or you're a Ukrainian investor protected by a bilateral investment treaty, that you should send all of those claims via the investment law provision so that Ukraine's reparations programs and limited financial infrastructure for reconstruction can be used on other forms of reparations. There are also some ongoing claims from the most recent conflict. A lot of foreign businesses that were targeted by Russia are using investment law to make claims against Russia. So this includes companies like Carlsberg, who were subjected to expropriation, and as well as some regulatory actions in Russia. Be for Ukraine, the NGO, has actually encouraged foreign businesses to leave Russia completely and to use investment law to recoup any losses that are imposed on those businesses for leaving Russia. So we have seen Russia adopt a law that says that if you're going to leave, foreign businesses that want to sell off their assets have to sell to a Russian entity. They can't just leave and take their stuff with them. We've also seen Russia expropriate physically and regulatorily assets within Russia that are owned by foreign businesses that have either left or that are from hostile states like Denmark. So these cases are pending. They're too new to have gotten through the investment law cycle, but they do look quite promising that these kinds of cases will be successful. In addition to the activities that are happening within Russia itself, there is an upcoming publication by this guy whose name I'm not going to try to pronounce, with apologies to him. But Professor Nagy has said that Ukrainians can claim compensation for war damages, even those that are occurring within Ukrainian territory, against Russia under the Russian-Ukraine bilateral investment agreement. His approach would be a quite expansive approach from an international law position, and in a different context, I would argue against the interpretation of the bilateral agreement the way that he's suggesting for it to be understood. In particular, he says that a lot of the Ukrainian assets in Ukraine that are damaged by Russia's invasion fall under the jurisdiction of Russia. That's from an international law perspective, a little bit of a dangerous argument to advance, particularly for Ukraine, which doesn't want to cede that territory as being controlled by or under the jurisdiction of Russia. From an investment law perspective, however, the tribunals tend to take a very robust understanding of jurisdiction to ensure the protection of foreign investors. So it is likely that you will see the cases come out the way that he says that they should, which is that Ukrainian property within Ukraine that is damaged by Russian activities should fall under the protection of the investment agreement. He also expands the understanding of investment a little bit more than I think a lot of international investment law scholars would, to go to almost all economic assets. The problem with using investment law the way that he would suggest is that it's a quite expensive avenue to go. So while there's a theoretical argument to be made that investment law could be used to make widespread claims by Ukrainians against Russia for all the property damage being done by the conflict, the reality is I think practically that's not an actual option for Ukrainians, because it will require a lot of expensive litigation under the investment regime. But it's a possibility. The flip side of that is that all those protections that Ukrainians have used against Russia can also be used by Russians against Ukraine. There are several claims that are pending against Ukraine. I know I already outlined some of them. Others have been threatened. Sometimes these are via the Russia-Ukraine bilateral investment agreement. Sometimes these are via other investment agreements. Because these are several years behind the Crimea cases, we don't have any decisions. The claims have been made on the basis of targeting and freezing assets by Russian oligarchs using the expropriation claim. You also will have cases that are under full protection and security protection, and that requires Ukraine to protect Russian assets from the impact of the conflict or the riots. The full protection and security provision in some interpretations is quite strict. It's almost like strict liability. If you have had damage from a conflict or a riot, then the state is responsible for that. Other interpretations argue for due diligence. But the idea is that under full protection and security, any Russian assets that were damaged in Ukraine during the conflict could actually be attributable to Ukraine, and Ukraine could be responsible for providing reparations for that damage. You've also seen investment agreement and protections being used to justify the failure to turn over frozen Russian assets to Ukraine for reconstruction purposes. So I think most of you will be familiar with the fact that there are millions and billions of dollars of assets by Russians, owned by the state of Russia or by Russian oligarchs, that have been frozen in Europe and Canada and previously the United States. But they have been reticent, the governments of those where the assets are frozen have been reticent to turn over those assets to Ukraine or to use the assets for reconstruction in Ukraine or even for military assistance to Ukraine. They have used the interest on the frozen assets, so they freeze the assets and they take the interest off and turn that over, but they haven't, or use that for military assistance, but they haven't turned over the frozen assets themselves. And investment agreement and protections are why. So if you have Luxembourg freezing assets and turning those assets over to Ukraine, Luxembourg is then on the hook for providing reparations and the full amount of the damages from that asset seizure and turning over. And so that's why you haven't seen it happening, and it's also why you are unlikely to see those assets turned over as I think many would argue they should be. So that's two parts of the three parts of understanding investment law's impact during conflict. The third is this post-conflict reconstruction. So the important protections, again, are full protection and security, which requires Ukraine to continue to protect Russian property during the conflict, but also during the post-conflict period. That means any riots, but it also means just general vandalism. So any anti-Russian, painting on the side of a building, or throwing rocks through, I'm now thinking about what Americans are doing to Elon Musk's Tesla properties right now. That would be captured by full protection security protections, and Ukraine would be responsible for paying reparations for that kind of damage. You also have the fair and equitable treatment clause again, which can constrain regulatory reforms, and I'm going to talk about that a little bit more in a moment. And then you have the arbitration of full reparation, which requires significant financial allocations. So on average, it costs $8 million to defend an investment claim. Multiply that by all the potential investment claims that Ukraine could be facing during the post-conflict reconstruction. And you have a significant allocation of resources before you even get to any damages that the investor has had. All of that money comes at the expense of Ukrainian taxpayers, and it comes at the expense of other forms of reparation and other financial allocations. So your schools, your hospitals, and the reparations that are owed to Ukrainians who have suffered from the conflict, all of that is impacted just by the existence of the arbitration and this obligation for full reparation. When it comes to the post-conflict reconstruction, I frame post-conflict reconstruction around the four pillars of transitional justice. You have truth, which are non-judicial and judicial efforts to identify what happened, who was harmed, and who was responsible for the conflict and associated breaches of human rights and humanitarian law. You have justice, which are criminal prosecutions and civil claims aimed at holding people accountable. Reparations, which are the programs aimed at addressing the harms experienced by people, particularly violations of human rights and humanitarian law. And you have guarantees of non-recurrence, which are legislative reforms that are aimed at ensuring that the past violations of human rights and humanitarian law don't occur again. In each of these areas, investment law can constrain the ability of Ukraine to address the conflict and to address the harms experienced by Ukrainians. So when it comes to truth, the Bywater Gulf versus Tanzania case found that extrajudicial statements by the government that harmed an investor's reputation can breach a full protection security clause, even when the tribunal itself found that the investor was actually responsible for the damage done to its investment. So in that case, the company failed to make improvements that it was supposed to have. There were a lot of riots against the company and protests. Government officials spoke out against the company. The company's worth dropped significantly, effectively eliminating the company, and it then had to turn over its operations to the government. The tribunal found that it was actually the investors' actions that caused the harm to the investment. But because they had these extrajudicial statements, they also found that there was a breach of the full protection and security provision. They didn't award damages in the end for the breach, but the fact that they found that these extrajudicial statements can, in fact, be a breach of the provision means that if you have findings by the government outside of a court decision, or statements by the government or statements by Ukrainians in a robust manner that harms an investor's reputation, you may have a breach of an investment protection. When it comes to justice, this requires individual prosecutions, and it requires the same kind of burden of proof that you would have in a non-conflict, non-post-conflict situation. So you cannot inverse the burden of proof to show that any kinds of contracts that occurred during a particular time were likely the result of corruption. You can't inverse the burden of proof to show that certain actors that are in the inner circle of Russia's political or military power were likely involved in an armed conflict, or likely involved in human rights and humanitarian law violations, or are responsible. There has to actually be a quite targeted protection or targeted investigation and prosecution of the individuals. Anything less than that will likely breach the fair and equitable treatment provision. For the reparations programs, it requires non-discriminations on the grounds of nationality. So you have to treat Russians who have lost property the same as you would treat Ukrainians who lost property. It also requires full reparation for all of the losses. In the end, that can recreate inequalities and constrain the finances for Ukraine. So Ukrainians would be required to ensure that if a Russian oligarch owns 5 properties within Ukraine, all 5 properties are subject to reparations. And that can mean that Ukrainians who suffered but didn't have tenure on land or didn't have tenure on property actually can't get reparations or get less reparations because the financial allocation has to go in a particular way. And then when it comes to guarantees of non-recurrence, Anil has already addressed the way in which this can significantly limit regulatory changes, but that also means regulatory changes related to the conflict. So anything that you're looking at in terms of significant reforms to reward people for the fact that they participated in the conflict on Ukraine's behalf, to limit certain types of activities by Russian companies that were involved in the conflict themselves or that supported the Russian military during the conflict. All of those kinds of regulatory changes have the potential of triggering investment law claims. So that is, one more slide, which is the experience of Colombia. We have seen this negative impact on transitional justice already in Colombia. So the land restitution program is under attack from investment law. Their land restitution program had inversed the burden of proof required to make claims, so that they found that if a land transfer had occurred within a particular territory during particular times, it could be presumed that it was not done in good faith and that it was actually done as a consequence of the conflict. And it switched the burden so that the purchaser or the owner of the territory or the land at the time had to prove that they had engaged in a full good faith exchange of property. But that meant that a lot of the large land acquisitions that were done associated with widespread human rights violations. So in Colombia, you had a lot of what's called land clearing. So the parties to the armed conflict would go in. Oftentimes they were paid by companies to do this, or they were local businessmen would use this activity. They would go in, they would kill and torture people until they left the property, or they would just kill and torture people to take the property. And then they would transfer the title, sometimes even via courts, but often via corrupt decisions or lies. And Colombia recognized that to ensure a long-term peace, they needed to redo these kinds of land transfers, and they needed to take that land back and restore it to the people who originally owned the property. But that, again, that inversing of the burden of proof risks fair and equitable treatment protections in investment law. I first warned about this in 2016. Most recently, 3 Colombian scholars did a study assessing whether or not my predictions were true, and they found that the land restitution judges treated foreign investors differently out of concern for investment law protections. So even if we're not seeing a lot of cases out of the investment law, we're not seeing a lot of cases under investment law being brought because of the land restitution program in Colombia, but instead what we're seeing is that the judges aren't doing what they would have done otherwise because of the threat of investment law. So here you're seeing that regulatory chill that Anil talked about. That was a lot of information and a bit of a whirlwind on investment law and armed conflict. So I look forward to a lot of discussions. And I'm sorry, I think I went too long.
Thank you so much for, despite being set the insights, but very deep and thoughtful, go into investment agreements concerning conflict, especially the war between Russia and Ukraine. We can open the floor. Does anyone already, because I have a lot of questions, but we will give first the option to our participants. Does anyone wants to raise the question? Yeah, okay. Then can I start asking because while listening to both presentation, it was very insightful for me, not being an investment scholar, not being an expert in the field, and I'm coming from human rights law and specifically European Court of Human Rights, and there is also this share of responsibility in jurisdictions during wars and conflicts. So almost in all cases, interstate cases in European Court of Human Rights, there also were cases where both states, victim state and aggressor state, were recognized reliable for human rights violation during wars or conflict. It was same in Azerbaijan and Armenia, for example. A lot of cases were held in front of. And in this case, I'm wondering how does investment law correlate with international humanitarian law and international human rights law in terms of if we do not have reservation in the investment agreement about conflict of war, what is about the right to the self-defense of the state during the conflict? So how they overlap can be the general human right, internationally recognized human rights, which allows the state to just sign out of the agreement, or there is no that possibility and we still are obliged, like Ukrainian government still is obliged to bear the responsibility under that agreement. So it's just interesting how it is working in human rights investment law, and how does it correlate with other international laws. It was my first question. I have other ones, but I'm not sure whether it's appropriate.
Should I just go for the one part of this question? I'll leave the IHL part to Tara. But there's interesting instances where you have investors, for example, bringing claims to the ECHR because they're, relying on the right to property, and being successful. In fact, there were Russian investors that brought cases against Russia and were successful. And in parallel, they brought claims in investment in front of an investment arbitration tribunal for the same loss, and were also successful. But the amounts of compensation that were awarded between the two regimes are completely different, because European Court of Human Rights does not award, and I think the award that the Russian investors, the compensation that was awarded to Russian investors in that case, by the ECHR was the highest ever compensation that the ECHR itself awarded. But the investment tribunal one was still, I think, at least 50 times more than what was awarded. So there's that one aspect is that you might sometimes see, and there are other instances of this, where individuals or companies are bringing claims under both systems. And then there are, and I'm going to the question of where there are clashes between the provisions. So do the investment treaty tribunals take human rights standards into account, or whether they factor states' human rights obligations into their decision making? I can't say they completely don't, but I don't think they do adequately. Sometimes states don't raise them in defending their actions. But even when they do, they might pay, lip service to states' human rights obligations. There are cases where tribunals said, look, states should simply comply with both sets of obligations. They have to comply with their investment law obligations as well as their human rights law obligations. They can do that. This is not an excuse. But there are other cases where so there's one case that I was going to mention in my presentation, which I didn't because we're running out of time. A case brought against Romania by a mining company called Gabriel Resources, and eventually Romania prevailed. So the investor lost the claim, and in that decision, the tribunal really engages with environmental standards, with participation of local communities in the process of developing a mining project. So there are instances where tribunals have done this, but they don't have to do it. Oftentimes they will ignore standards. I mean, sometimes even customary international law arguments that states might not be found valid by. They won't ignore it, but they won't find it necessarily valid. So I'm gonna pass it on to Tara on the IHL.
Yeah, actually, before I go into IHL and those specific clashes, I took Tamara's question as a different one on shared responsibility. So I took it as whether or not you could make a claim against both Russia and Ukraine for a breach of investment law for the harms that are caused by the conflict. I cannot think of any cases under investment law where both countries have been the subject of the claim, in part because you're not entitled to take a case in investment law against your own state. So Ukrainians can't take a case against Ukraine under investment law. They can only take the case against Russia. So I don't think that shared responsibility is a thing in investment law, but I'm looking at Anil to see if she's, nope. Okay. So I'm pretty sure that's out from an investment law perspective. It would mean one of the ways that human rights law can be complementary is by taking those kinds of cases under the European Court protections, the way that Anil talked about. So now more generally on the clashes between investment law and IHL and human rights. As Anil said, you will often hear tribunals take vague account of investment law or of human rights obligations. They'll say that the state has these obligations. They may even take it into account in sort of an extensive detail, talking about human rights. Sometimes, particularly when it's come to regulation around tobacco industries, they recognize that the state has police powers, legitimate police powers to regulate in the public interest, which means that they will find that there's not a violation of the fair and equitable treatment standard. That's not a uniform position, though, and oftentimes they don't find the police powers are relevant to human rights. There is largely multiple, because investment law doesn't rely on precedent, because the same investment arbitrators can come to conflicting decisions on the same facts. There's no consistency in the decision making. So when I say the same investment arbitrator can come to conflicting decisions, I literally mean the same investment arbitrator. So there is a case from the Argentinian water, three cases from the Argentinian water crisis involving the same arbitrator. In the first case, the arbitrator found that the facts meant that Argentina was in a crisis, and therefore the defense of necessity existed, and it wasn't bound by any. It wasn't the regulations that it took were legitimate, and it was precluded from having an internationally wrongful act. Under the same facts, that same arbitrator found in the second case that Argentina was not in a crisis. Same time period, same crisis, same regulation. In one case, there was a crisis that precluded international wrongful activity or responsibility. And in the second case, it wasn't precluded, and Argentina was responsible. In the third case, Argentina challenged the arbitrator's appointment and said this isn't appropriate. He clearly is not exercising independent thought on this. He's coming to conflicting decisions on the most basic of facts. So how can he be entrusted with a third case? And the president of the arbitration body said it doesn't matter. He's still appointed. So there's literally no consistency. Sometimes you have cases that take a great deal of account for human rights. A lot of times you have cases that don't take account for human rights, or that say, yeah, there's a conflict, but you're expected to abide by both, and the existence of human rights humanitarian law doesn't exclude that. More generally, the problem is that investment arbitrators have zero to very little knowledge of international humanitarian law or human rights law. So the very first case to be brought under an investment treaty was AAPL versus Sri Lanka. It was brought by British shrimp farmers against Sri Lanka for damages suffered during the conflict. Sri Lanka explained that it had invaded the farm and caused the damage because it had reason to believe that the Tamil Tigers were operating a base out of the farm, and that there was ongoing military activity at the farm. Under humanitarian law, that is a legitimate reason to go onto the farm, and as long as the attack is proportionate to the military advantage gained, it's a legitimate attack. The decision by the arbitrators in AAPL versus Sri Lanka was that Sri Lanka should have issued an arrest warrant for the individual Tamil Tigers and gone through the court cases to have them arrested. There's no foundation in humanitarian law to support that decision. If you said that to any military leader, they would laugh at you. But instead, Sri Lanka was forced to pay the British farmers for the damage done on the basis of 3 investment arbitrators don't know anything about humanitarian law. I don't see the tribunals taking humanitarian law seriously because they don't know enough about it.
Yeah, thank you very much. I have one following question from your answers. So, why do you think there is such an inconsistency, for example, in Argentina's 3 cases? Because there is still an overlap in my perceiving of European Court of Human Rights practice during war and conflicts, because there is a case law and there is a Georgia versus Russia case where the court did not recognize any of these country jurisdictions during the active phase of war. So there is no country responsible for 5-day war in Georgia, in 20, like back to 20s. So the same suspicion arrives why there is an inconsistency in the same period of time in Argentina for the same context but different decision. Why do you find?
So the arbitrator explained it, and we know this because the president's letter, the managing body for that third case, explains that the arbitrator said that he wanted to focus on the panel's comity. So he wanted to make sure that there was a unanimous decision by the panel rather than issuing his own independent judgment that would differ from the panel's decision. And so he went along with what the majority was. And that was his own personal reasoning. The larger breach of the cases is down to the fact that, again, international arbitrators don't need to know anything about human rights or humanitarian law. They can be very narrowly focused. A lot of them are not even international law scholars. So we saw that more recently with a case called Eco Oro versus Colombia, where the treaty interpretation makes no sense from the perspective of international law. And the one arbitrator in that case that is an international law scholar, Philippe Sands, dissented in the case. So they don't know a lot about international law, or they don't all know a lot about international law. So there's no systemic approach to making decisions on these issues. They aren't bound by precedent, and they oftentimes feel that they themselves know the most. Sorry, this is just a general assessment that investment arbitrators tend to be quite arrogant about their own knowledge. And when they make decisions, it's based off of how they understand what the world should be rather than anything based foundationally in law. Because the substance of those decisions can't be reviewed, there's no way to hold them accountable for bad decision making. And because of how they're appointed, bad decision making can actually lead to better appointments for them in the future, right? So Ukraine will be defending a lot of cases, but generally speaking, you want to, if you're an arbitrator who wants to be appointed to more arbitration cases, you want to take the side of the plaintiff. You want to take the side of the investor, because their counsel is who gets to initiate all the future arbitration claims in the future. So you can get appointed to lots of cases because you engage in really bad legal reasoning. Sorry, that's a very cynical view, but it's also a very realistic.
So thank you for this very, very realistic responses, which is much appreciated. We have another question in the chat from Mariam Sharif, and the question is, could you elaborate on citizens not being able to sue their countries under investment law? Thank you. So
I can take that one. So technically so if we're talking about investment treaties, which we have been, because they're designed to protect foreign investors, they're meant to protect investors from the other contracting state. They're meant to be reciprocal. They're basically creating almost, I mean, some have argued that they're creating more favorable rights for foreigners than you get for domestic investors, and which they somewhat do. So because they only offer protection to investors from another state that is the signatory of the bilateral investment treaty, the nationals of that state, the whole state, will not be able to rely on the treaty. But what they do, actually, one of the most famous cases that relate to this was brought against Ukraine, is called what is called nationality shopping. I mean, that's what quite a lot of investors might decide to do if they want to benefit from, especially if they're opposition figures, if they're so the investor, I can't remember his name, I think it was Khodorovsky, this Russian kind of opposition kind of business person whose investments were all confiscated by the Russian government. What these type of figures do often, and this is, I come from Turkey, and in Turkey we have seen the same. Often investors who suspect that the incumbent government might, take action against their assets, might restructure their investments so that they move all the assets to a foreign held company that has an investment treaty. So basically nationals can bring claims, but they would have to engage in corporate structuring, investment structuring, to channel their assets through another state where the whole state has an investment treaty with. And that does happen. And it's also often carried out by large corporations as well. So not just, opposition business people, but yeah.
Thank you very much. Yes, we also have a question from Olena. Olena, would you like me to read, or you can spell it?
I can voice as well. Yeah, thank you very much for your presentations, and it's very, very interesting for us and very relevant for Ukrainian context, but also in other perspective. We have a lot of discussions and speculations about the US and Ukraine so-called mineral deal, of course. So there are a lot of speculations. We don't know exactly what could be signed or if it will be signed and so on. But to take this situation a little bit in theoretical perspective, could you share with us examples when constitutional courts stepped in to protect constitutional values if investment agreement could create the risk of violation of constitutional values?
So this has happened. I can maybe start with this, and then maybe Tara has more examples. This has, from my knowledge, most recently happened in the Eco Oro case that Tara mentioned earlier, that was brought against Colombia. This was a large mining project that would take place in indigenous territory, in territory that would be considered highly ecologically sensitive. So there were laws that were protecting this space. So there was this contestation from the start of the project, and it was owned by different investors, but the eventual one that brought the claim was Eco Oro. Whether mining could be carried out in this area. There was an exploration license that Eco Oro held to find out whether there were minerals, but there was delay. So Colombia was delayed because I don't think it's an easy task, as far as I understand, to establish the boundaries of this ecologically protected area. And anyway, long story short, the case, the facts of the case were brought all the way up to the Colombian Constitutional Court. There were challenges, and the Constitutional Court found that what Colombia did was basically that Colombia was required by the Constitution to protect this area. Yet and these arguments, so the findings of the Constitutional Court were part of Colombia's defense in the investment arbitration claim that Eco Oro brought against Colombia to argue that their investment was expropriated and that they were not treated fairly and equitably. So there's very little. So what investment arbitrators often do, and they did the same in this case, is that they're not charged with assessing constitutional principles or whether a constitutional court decision is relevant to what they're doing, because what they're doing is applying the investment treaty. And the investment treaty says X, Y, and Z. And they do not take into account often constitutional court decisions. I mean, we've seen this also in Europe. Sometimes I think, maybe they just don't think constitutional court in Colombia is good enough. But we've seen this also in a wave of renewable energy cases that were brought against Italy and Spain, when Italy and Spain reduced incentives that they were providing to renewable energy producers. The renewable energy firms brought these claims against Italy and Spain and some other European countries. But in parallel, they also challenged the constitutionality of these measures. So they challenged it through the administrative courts first, and then it went all the way up to the Constitutional Court, both in Spain and Italy. And both courts have found that it was well within the rights of these states under constitutional principles to actually reduce incentives, because they were trying to manage a financial crisis. They were trying to ensure that the electricity system was, sustainable, that they could maintain the electricity system and provide electricity to users rather than overcompensating the energy providers. But again, there are extensive submissions by Spain and Italy in these cases on the Constitutional Court decisions and how investors should have known that, look, Constitutional Court including the Court of Justice of the European Union. So not only constitutional courts, but the Court of Justice of the European Union even had a decision in regards to the Italian measures, which in all cases, tribunals, some have taken into account in the sense that if an investor was already, if these decisions were already made by the Constitutional Court and the investor has acquired the property afterwards, then they needed to form their expectations as to what would happen to the investment, taking into account that there are these Constitutional Court decisions. But other than that, they're often ignored and not really taken into account by investment tribunals, because they feel like the tribunals are often insulating themselves from everything else that exists in the legal realm, including Constitutional Court decisions and other court decisions.
Thank you so much. We have 2 more questions in the chat, even 3. So yeah, I can read them. First one is, can digital assets such as cryptocurrencies and tokenized investments be considered protected investments under bilateral investment treaties? The second one, are there any precedents or legal doctrines supporting their inclusion within the scope of investment protection? And the third question is there any mechanism for compensation for investors who suffer losses from the state actions if expropriation is a will of sovereign state?
Shall I do the asset one?
Yes.
Unless, Tara, do you know of any case? I don't know of any case that was brought in relation to cryptocurrencies, but yeah, they can definitely be captured by investment treaty definitions of assets, because they define assets really broadly, in the broadest sense possible. So digital assets, I think, might come under this definition.
Yeah, I was trying to very quickly get to the Russia-Ukraine bilateral investment treaty. Cryptocurrencies, because of how new they are, generally are not one of the enumerated or specifically identified investments, and we don't have case law that I'm aware of on this issue. But if we look at sort of the expansive language of the treaties, they're clearly protected. So I have the treaty for Russia-Ukraine now. It says investment shall denote all kinds of property and intellectual values which are put in by the investor of one contracting party on the territory of another. And in particular, movable and immovable property, monetary funds, and also securities, liabilities, deposits, and other forms of participation. So that's quite broad language, and you would find it captured. Now, Tamara, I can't see the other question that you asked, and so I missed it.
Yeah, I just repeating it because it was sent to direct messaging. Yeah. Is there any mechanism for compensation for investors who suffer losses from the state actions if expropriation is a will of sovereign state?
Yeah, so the fact that it's a will of sovereign states doesn't mean anything for investment law. I mean, this goes to the long debate about whether or not signing onto any sort of treaty is an act of sovereignty or a constraint on sovereignty, right? And the consistent approach within investment law is that it is a choice of a sovereign to engage in investment law, and therefore any constraint on sovereign decision-making is itself an act of sovereignty, right? So you have chosen to use your sovereignty in the way of ratifying the investment treaty or an investment contract or your national law on investments. And so all of those mechanisms continue to apply in these cases.
Though I would just add that I think any I think under general human rights law as well as constitutional laws of many countries, I guess, expropriation has to be done for a public purpose, to be lawful at least. That it has to be done for a sovereign purpose, and that it has to follow due process. It has to provide adequate compensation. There's often the question, many disputes that do come to investment tribunals on expropriation actually don't deal with direct expropriation. There are very few of those nowadays. States don't often expropriate unless it may be in the context of armed conflict or other regime changes. We had this in Venezuela when there was a regime change. So you might have that, but most cases of expropriation are indirect expropriation, most claims at least, where you don't have taking of property like you would have in direct expropriation, but you have interference with the use and enjoyment of the property through other means. But yeah, it always has to be for a public purpose.
Thank you. Does anyone else has a question? I still have one more, not related to the conflict, but more to general discussion about sustainability agenda and developments in the field regarding investment. And my question is, how do you perceive legal developments in EU, actually, yes, EU environmental so-called taxonomy and the proposal of social taxonomy requiring yes, integrating sustainability elements in investment checklist for companies. There were discussions about the backsliding of these taxonomies and the effectiveness of the implementations of the provisions by companies and by states. How do you perceive developments in this field? Are they effective or?
Shall I go for it? So if do you want us to kind of focus on how do this relate to maybe investment law or generally
No, investment law, yeah, because
okay, yeah. So I feel like there is no direct connection between the two, although if we think about the taxonomy and the EU Green Deal, I mean, lately I have been working on this. What you see is there's real risk of interference from investment treaties when it comes to the implementation of the taxonomy or you know, even CSDDD, which is, you know, what format it will, you know, be transformed into, we don't know. But the fact that states are now required to or being asked increasingly to green everything, move away from fossil fuels, is a big serious threat to there's a big serious threat from investment treaties, I think, to implementing this for the EU and for also because now EU has joined the Energy Charter Treaty, I think, if I'm not wrong. So the EU itself could face claims from energy firms primarily, but also for individual member states in the EU if they do implement their EU obligations or requirements from the EU under the taxonomy to green their economies. That means shutting down coal power plants. This has happened already. If we look at the Netherlands, it's one of the first countries to start shutting down, early retiring coal power plants, same with Germany. And as a result, they did face threats of claims from energy investors because of these early closure threats. They did settle. The Netherlands did settle with the investors. Uniper and RWE, I think, were the two investors. But these claims were really, I think, they really shaped the terms of the settlement that was offered, probably. So yeah, that is my take, but I don't know if that addresses the question. Tara, do you want to add anything?
No, I mean, I think you covered it.
Thank you so much. We are going to the closing of our session, but still maybe someone has a question, pressing one, which needs to be answered. If not,
I was gonna say, if anybody wants to write a PhD or a dissertation on digital assets and investment law, I think they should do it because that's an interesting subject to research.
Yeah, and we were discussing with Olena previously that it's so interesting topic, but not a lot of scholars are really engaged deeply with working within this topic. So it was extremely interesting to listen to you today. We are so grateful to our speakers, Anil and Tara, and we're looking forward for next webinars. The next one will be very soon on Wednesday. So we are inviting all of you to join us and to further discuss BHR issues with our incredible speakers. Thank you so much.